This is case 2023-0128 in the matter of Deborah Dascenzo's Paul and Brian Paul.
Morning, Attorney Gordon. I understand you've reserved 1 minute for rebuttal.
May it please the court, I'm Joshua Gordon. I represent Deborah Dascenzo, who is here this morning. I reserved a minute. This case is an establishment of alimony. At the time of divorce in 2017, the family court declined Deborah's request for alimony on grounds of inability to pay and insufficient need. And as a result, the court did not make an alimony order. On the pre-printed form, the box labeled alimony is not checked. And thus, there's no alimony order to modify, and this is an establishment case.
So if the form included a check and a zero, would that be a different argument?
Absolutely. Then there would be a alimony order for $0, and anything subsequent would be a modification. Dr. Paul's position requires this court to interpret the lack of an alimony order, in fact, as actually an alimony order, as you suggest, but for $0. And it is possible, as you suggest. But here the box was unchecked, and there's no alimony order, and you can't modify an order that has not yet been established, and this court should reverse on that grounds.
But it's also your position that if we view it as a modification, that standard was satisfied as well?
If this court sees this as a modification, Deborah is required to prove a substantial unforeseen change in circumstances, and foreseeability depends upon what the parties, plural, actually anticipated in the matter of Arventus. Thus, the chronology, what Deborah knew when, matters. In 2014, there's a party separated, and Deborah filed for divorce. In 2015 or 16, Mr. Paul presented a forged court order to the school district. I don't know the exact year. In August 2016, the first day of the divorce hearing, Deborah is testifying. The school superintendent appears in the courtroom, apprises the court of the forgery. The hearing abruptly ends, and the court suggests a referral to the county attorney. In January 2017, that's about 3 months later, the second day of the final divorce hearing, Mr. Paul is still a medical resident with 2 years left and a very moderate income. His criminal defense attorney was in the courtroom. He says he was then negotiating with the state whether or not he would be charged with a felony or a misdemeanor, and they were discussing possible dispositions with the county attorney. And that was the last thing Deborah knew, because in March 2017, there's a divorce decree. At the time, she could reasonably foresee Mr. Paul would be charged with a felony, go to prison, and lose his career. Later, in June 2017, Mr. Paul pled to 2 misdemeanors. He was sentenced to 60 or 90 days, I'm not sure which. And then in July, a month later, Dartmouth withdrew his residency, his salary, and his benefits. Deborah filed a notice of appeal in the divorce case, which evidenced her contemporaneous understanding. The question she presented to this court was whether the family court should have ordered alimony where pending criminal matters resulted in inability to obtain physician's license, restricting his earning potential.
And that was filed when?
That was filed that was filed within 30 days of the decree in March 2017.
Why was there the delay between 2018 and the time that the petition to change the court order was?
There's nothing in the record about why, but the statute doesn't care why somebody procrastinated. The statute cares that the petition was filed within 5 years of the decree, which it was by a few days. A month after...
Help me with the dates, because I get hung up here. The final decree, the orders underlying the final decree were signed on March 30th in 2017. Yeah. We don't have the notice of decision, so we don't know when that actually issued. And then there's a reference, I think it's in your brief, about Judgment Day being February 2018. So I've got this time frame that is confusing.
Yes, that was a dispute below, but it hasn't been appealed, and I think the whole thing was resolved that the 5-year time frame was complied with. That was resolved below.
It started on the March date.
I don't know, Your Honor, because it wasn't an issue here. I didn't follow it carefully.
Okay.
I do have a similar question. You said was just commencing a 2-year residency requirement?
Pardon me?
That at the time of the divorce, Dr. Paul was just commencing a 2-year residency requirement?
I believe he was, the record is sparse on this. He was in a residency program, and I think he had 2 years left on it. Whatever Dartmouth requires. I think that was the situation at the time.
A second residency program.
Maybe it was a second residency program.
There was the required residency, and then there was an additional public health residency that he was in the middle of. That's what I understand the record.
That's possible that that's true. I found the record unclear on what exactly he was doing when.
But if he had completed his requirement for that first residency and he was entitled to go out and practice, doesn't that make a difference?
Well, he hadn't been a licensed doctor yet. He had yet to, there was something left of his education. Whatever the precisely it was is unclear to me, but he was not done with his education and he had not yet been gone through his licensure to be a doctor.
But wasn't her overall alimony argument that one way or another he had an ability to pay? Well, regardless of the criminal piece.
At the time of the divorce, he was making, I think, $50,000 or $60,000 as a stipend from his residency, and her argument was he had the ability to pay something then. The court disagreed. A month after the divorce, he's working at menial jobs, and his child support is reduced to a statutory minimum. But unbeknownst to Deborah, and this is after the divorce, there were heroic efforts to salvage Mr. Paul's career, and he was only charged with misdemeanors rather than felonies. He kept his residency. Mr. Paul was involved in these efforts. His divorce and his criminal lawyers were involved, and the judge was involved, but Deborah was not. She was not a party. She was not a victim. She was no longer married. The father was estranged from the child, so there wasn't even that opportunity for her to gain information. At the time of the divorce, the last Deborah knew, there was going to be felony charges, a lost medical career, menial job, child support at a minimum, and Deborah didn't have any facts to foresee anything other than Mr. Paul had tanked his medical career by his crime. And there are a lot of ifs between Mr. Paul's transition from felony to doctor. There's incarceration, there's completing the medical school or the medical residency, there's regaining the lost residency. He has to finish it. He has to survive the licensure with a record of a crime of moral turpitude on his record. He has to go through a job interview with those same issues, presumably, and then actually get a job that earns a lot of money. I want to address my sister's waiver argument, which is based on an unfortunate misuse of technical terms in Deborah's petition. But her claim that this was an establishment of alimony rather than modification was presented to the family court, argued, addressed by the court, and in her original petition, Deborah requested alimony under separate statutory grounds than merely modification. She asserted that justice requires alimony, referring to RSA 458-19 Roman numeral 2, which says that the court may make alimony orders whenever just and equitable, and you can see that in the appendix at page 192, paragraph 7.
Is there any dispute as to which version of the statute applies?
2014 version, and that was not.
Because of the date of the final decree, not the date of the arguably new request for alimony.
Correct. It's the date of it's the statute at the time of the divorce, not now. In August 2022, in the modification establishment case, the court requested, took notice that this was an issue and asked the parties for a trial memorandum. And in Deborah's trial memo, she argued it was establishment. And you can see that in the appendix at page 233, paragraph 12, 13, 16, and 19, that is not cited in my brief. Alimony is not like a criminal or domestic violence where proceedings are limited to the allegations in the initial filing, and in any event, the family court squarely addressed the issue, and it was preserved and not waived. And finally, this issue of underemployment, which I see all over my sister's brief, it's not relevant to this appeal in any way because it doesn't help in distinguishing establishment from modification, and because it's unrelated to foreseeability.
Do you think that lifestyle during the marriage is similarly not applicable?
It doesn't matter to the issues before this court. It certainly matters to, if there's a remand from this court, it matters to the family court about whether Ms. Dascenzo is self-sustaining and what her employment situation is. It will matter later, but it doesn't matter to the decision here. Thank you very much.
Thank you, Attorney Gordon. Attorney Connor. Attorney Gordon.
The checkbox is everything. There's either alimony or not. It's a binary issue. And the question about whether, when you ask for alimony, there's no law saying that establishment must be in response to the first request. And actually, you may have to act for alimony in the initial proceeding or risk forfeiting it later. And there's some language in the matter of Maynard in 2007 saying that. And seeking alimony at the time of the divorce, Hoyt said, is just one of several possible situations. And if you don't get alimony the first time and you come back repeatedly within your 5 years, and the court keeps saying no, each time is an establishment if there's no alimony order, unless the court orders a $0 award.
But wouldn't it be different if she had never asked for alimony in the first place?
No, it wouldn't be different at all. There's no limit in the statute about how many times you can come back, and in fact, I think the statute encourages you to come back whenever it's just and equitable. And so there's no res judicata type of issue.
People may agree to no alimony agreements if you final orders in reliance, knowing that they can come back within the 5 years if things change, or not.
Maybe. Thank you.
Thank you, counsel. Case submitted. Court will take a brief recess.
Rise.